Hi everyone, welcome back to the channel. I'm Brandon Silver, a construction, contentious and transactional lawyer, and today we're going to be talking about liquidated damages versus general damages in construction contracts. These two types of damages come up often in construction disputes, especially when projects run late or don't meet expected standards. Understanding the difference between general and liquidated damages can help both contractors and employers in protecting their rights in the event of a breach. So, let's now first talk about what are liquidated damages. Liquidated damages is often abbreviated as LDs or LADs, and in simple terms, liquidated damages are a pre-agreed amount that one party will pay the other if there is a specific breach of contract, most commonly the breach of delay in completing the project. These damages are typically stated in the contract as a set amount per day or week of delay. The purpose of liquidated damages is ultimately to provide certainty by setting a fixed amount payable in the event of a breach. This means that ultimately both parties know the financial consequences of a delay from the outset. So let's now give an example. Let's say you've got a project, and in the project there's a contract, and it says that there's a liquidated damages clause stating £1,000 per day of delay. If the contractor finishes the work 10 days late and is not entitled to an extension of time, then the employer can claim £10,000 as compensation. 10 times 1,000 per day equals 10,000. And that's how the liquidated damages clause would work. Now, importantly, there's the question of whether or not a liquidated damages clause would be enforceable. Now, under UK law, for liquidated damages to be enforceable and not deemed to be a penalty, the test used to be, under the UK law, whether or not it was a genuine pre-estimate of the loss. However, the law has now changed and that is no longer the test. There is now a new test in determining whether the liquidated damages provision will be enforceable. The test is whether or not the amount of liquidated damages is out of all proportion to any legitimate interest of the innocent party. Ultimately, the provision must not be extravagant, exorbitant, or unconscionable. That is the test that now applies, and this is now a higher burden to get over the line for liquidated damages to be unenforceable. Courts tend to find that liquidated damages are enforceable, and you've got your work cut out to try and show that they are unenforceable. And this new test is a higher threshold for showing that it would be unenforceable. The important point with liquidated damages is that you do not need to quantify or prove your actual loss suffered. You don't need to do that. It is the fixed amount agreed in the contract, and that is how you would claim the monies. Now let's look at general damages. Unlike liquidated damages, general damages are not predetermined. Instead, they are awarded after a breach to compensate for actual loss suffered. General damages cover a range of losses, including financial costs. Ultimately, the purpose is to put the injured party in the position that they would have been had the contract been performed correctly and fulfilled as agreed. So, let's give an example. If a contractor's defective work forces the client to spend extra money on repairs, the client would be able to claim those repairs as general damages. It would be the actual costs incurred. Unlike in liquidated damages, there is the requirement of proof. General damages require evidence of the actual loss. The party that is claiming the general damages must demonstrate the direct link between the breach and their financial or other losses. While liquidated damages are typically limited to project delays, general damages can cover a wider range of breaches, such as defective work, non-performance, or financial losses resulting from additional expenses. So let's now give some considerations. For employers, liquidated damages are helpful when the primary risk is delay, as they provide a straightforward remedy without needing to prove loss. For broader risks, however, general damages will often be more flexible for employers. For contractors, if you agree to a liquidated damages clause, it provides predictability in terms of potential liability. So, my final tips. Draft the contract carefully, Make sure the liquidated damages clause is not out of all proportion to any legitimate interest, because that will avoid the clause being unenforceable. So make sure the liquidated damages clause is drafted well. If you're claiming general damages, make sure you have all the documentation. You need to maintain detailed records of any additional costs and the impacts directly linked to the breaches. And finally, my advice is to try and seek legal advice. Both liquidated and general damages carry risks if misunderstood. So please do not hesitate to contact me if you're unsure about your obligations or entitlements. So, thanks for watching. I hope this has ultimately clarified the difference between liquidated and general damages in construction contracts. Ultimately, understanding these distinctions is key to managing risk and knowing your options if things don't go as planned. I hope you found this helpful. Please like, subscribe, and leave a comment with any questions or topics you'd like me to cover next. Thank you for listening. See you in the next video.